Thank you. If the court is ready, you may present your case.
As my counsel before me, this is the first case I have ever had that I was not the attorney at the trial of this matter. So interesting that we both had that going on. And I did want to say hello to you, Judge Davis. Welcome to the Court of Appeals. This is my first case in front of you. Your Honor, I would like to reserve 3 minutes for rebuttal.
3 minutes.
Your Honors, this is a pretty straightforward case. It's a custody dispute. It arises from a divorce, but the financial portion of the divorce was mediated and settled long before the custody issue was ever heard. It was heard in front of Judge Howard Upchurch. Unfortunately, the position I'm in is my standard of review is abuse of process, so I have to say some strong-worded things about what the court did. I want you to know, and certainly him to know, on remand, I have nothing but the utmost respect for Judge Upchurch, and I thought he, from looking at the trial, it looked great, and the Rule 59 motion looked great, but I feel he has committed abuse of discretion and is in error. There's just no two ways about it. Running very quickly through the applicable law to get to, and then I'll apply the proof to it. There are 14 factors that the court looks to during a custody dispute, and none of them are dispositive. And the law is very clear that while the court is to basically go through each and individual element and say which party it favors, if either, the court doesn't necessarily have to say, well, you win 6-5 with a tie on 3. It's which are more important and which are not. And that's where Judge Upchurch went awry. He found for the mother on 3 of them. He found for the father on 3 of them. And he found that there was neither here nor there on the remainder of them. There are 2 that I want to focus on, but I'll get through all of them first. This was a tumultuous marriage. These people, as the mother said, were mismatched. And there is a lot in the divorce about my client's behavior towards the mother. There's nothing about his behavior towards the children. And she acquiesced to a temporary parenting plan of 50-50, and she acquiesced to a parenting plan of 50-50 at the divorce. So I believe it's disingenuous for her to say that her problem with the father is that he has an inability to parent. She has never said that. Contrary to that, my client has testified that he does not believe that the mother has the children's best interest in heart, and that largely she worked and he parented. And there's something that I had noticed in Dr. Hillner's report that I did not put in my brief, but it bears mentioning, it's on page 5 of his report, that when the mother was asked what the best interest of the children would be and why she would be the better situated parent, she has several sentences of why she is says, I would like to be the primary parent, the school parent, the dependable parent. I want the kids with me a minimum of Sunday night through Friday afternoon. Then their father could pick them up on Friday afternoon for a fun-filled weekend. Then I pick them up Sunday night. Why? Because I am stable, parenthetical, great for school days, and Ray can be quite fun when he is not quite angry. And then the telling statement. Someone always makes the telling statement. After that, she can't help but say, also, I have worked weekends selling at festivals and markets since 2013. It might be more enjoyable for the kids to play with their dad than working with me on the weekends. It's all about her work schedule. That's what it's all about. That's what she wants to accommodate. That's why the schedule is she has them up through Thursday and my client has them on the weekend, because she wants to work. That isn't necessarily in the best interests of these children. Now, Judge Upchurch found that it was in the best interest of the children because of stability and continuity. That's what he harped on. And he said it in very, very strong language, which is why I believe it is an abuse of discretion there. It's factor 10, and you have to cross-reference factor 10 with factor 1. Factor 1 is stability of the children with each parent, not the infrastructure of their lives, but their relationship with their parents. Judge Upchurch found that factor 1 favored neither parent, that both parents had relationships with these children. He also said that the primary caregiving, factor 5, was split equally between the parents. So he's not putting any weight really on the parent's ability to parent. He's not putting any weight on what each parent's relationship with these children are if you look at the factors that go to things other than infrastructure. It's number 10, brought in line with number 1. Number 10 reads in the statute, the importance of continuity in the children's lives and the length of time the children have lived in a stable and satisfactory environment. And I quoted him. He says, the children have lived in Hickman County in Centerville now for 2 years. That's false. And that's why this is an abuse of discretion case, because he is basing his ruling on evidence that is not true. It's factually inaccurate. The children have never lived in Hickman County more than 50% of the time. And that brings us to the other avenue of why he made his ruling as he did, and I'll get to that in a moment. But he puts, now, stability and continuity. A lot of courts describe that as the alpha and omega of parenting decisions. And then he goes on to say, and I do put a great deal of weight on that, and I find that stability and continuity can and will be achieved by allowing the children to remain with the mother, and the mother being the primary residential parent. That's false. This was a straight up 182.5 split, 50-50. The children were not with the mother.
With that in mind, that each party will receive the exact number of days and hours, so to speak, with the child, the children, what makes it significant that the primary residence be with either party, quite frankly?
The issue can be school. The issue can be, that's the big one, really. And the school that the children are in currently, my client testified that he would prefer the children to be in a Montessori school where he lived. He even had an expert testify to how good that school is. And frankly, it's 200 miles away from my client. That's really, honestly, just not fair nor just. She just moved 200 miles away. Now,
that's not going to affect his parenting time with the child, though.
No, it doesn't affect the time he has with the children. It does impact the efficacy of the time he can have with the children. There was quite a bit of testimony, and Mr. Bates referenced it in what occurred in the Rule 59 hearing, that my client is required to have another residence in Murfreesboro, Tennessee, in order to be close to the children in the event that he needs to be there. School activities. At one point in time, actually, after the trial, the children and the father got COVID and had to quarantine, and they had to quarantine in Murfreesboro. And the problem with that is the children's entire family, save 3 people, live in the Hamilton County, Shelby County, Shelby County area. Over 70 relatives were referenced in the trial that live where these parties chose to live together and raise their children in southeast Tennessee. If there had been any court order in place...
Not Shelby County. I thought you said Shelby.
No, I'm sorry. No, well,
Okay.
yes.
I was
In the chat.
confused. We were bringing
Yes.
Memphis in here. This is
No,
okay.
I completely misspoke, Judge.
Okay.
I'm sorry. That is not my area. I generally don't practice down there. Thus, the reason why I was not involved in the trial. But southeast Tennessee is where these kids are from. That's where they've lived their whole lives until mom just up and went 200 miles, focusing on saying that the father was abusive to her, saying he threatened to kill her. But if you read the statement, it was a very bad thing for him to say, but he didn't threaten to kill her. It was just a mean thing to say. People in acrimonious divorces say mean things together. That doesn't give her the right to steal his children and move 200 miles away. And that is the second thing that the judge based his decision on. He found that the mother would be more likely to facilitate a relationship between the children and the other parent, pursuant to number, I believe it is number 2 of the elements that you look to in a custody dispute, because the father took out a TRO on facts that the judge found to be not based on anything that should have given him a TRO. As this court knows, anybody who's been a trial practitioner, anybody who's seen a trial, that TRO is drafted by your lawyer. You say, are these accurate? Yes, and you sign them. There's more to that TRO that the attorney did not put in there, and that is, this woman took his children, this man's children, young children, 200 miles away and refused to tell him where they were. And that came out in the testimony that was his real reason, and the judge used that against him and said, you took a TRO out under false pretenses. That's not why you wanted it. Why you wanted it was because you didn't know where your kids were. Well, yeah, absolutely. That's done on a daily basis in every jurisdiction in this state. When someone absconds with children, you get a TRO to bring them back to you. And when he got that TRO and got the children back, as soon as he got them back and was assured, because now he had a court order protecting him, 2 weeks later, he agreed to a 50-50 schedule with her. He wasn't doing anything to try and keep the kids away from her. He was trying to stop her from keeping the kids away from him. He's not the one who moved away. She moved away. The judge saying that he was using court auspices to deny this woman parenting time is false. It's just not true. So the judge used two large, substantial reasons to grant mother a primary residential status and keep the kids in school where they are, forcing my client to have nothing but weekends and having to go get them and not be able to participate in their school on two factors that are false. The judge then minimized other factors. Abusively, as far as discretion goes, I don't know, but he minimized them, and he should not have. The division of who's the primary caregiver with the likelihood to give the children what they need educationally with doctor's appointments and whatnot. To this day, the children's doctors are in the Chattanooga area. They live in Centerville, but all of their providers are in Chattanooga. That's never changed. My client on Fridays, when the children aren't in school, takes the children to their appointments. The mom never went to one therapy session with Juliet Thomas after the intake. She's the one who asked the court to have her appointed. She said she needed therapy because she needed to be able to prove to the court what was going on between the children and the father. Then she never showed up again. So she definitely is not taking care of these children as far as medical purposes go. I do not want to suggest to this court that I feel that this woman is medically neglectful of her children. She's certainly not. She definitely has some eccentricities on how she does care for children. She uses old Tennessee methodologies for some of the things she does that I would personally disagree with, but I'm certainly not asking the court to hold that against her in any way, shape, or form. But the bottom line is, all of these factors that the court said either were not, and I've run out of time, so I will let Mr. Bates talk, and I will come back to that in rebuttal.
Thank you, sir. Yes, sir.
Please the court, I'm Douglas Bates IV from Hickman County. It's my first time to be in the Eastern District, and it is quite a privilege to be here. I believe the most important factor in this case was the credibility of the father was significantly at issue. The TRO revealed, it was not necessarily as my friend discussed. There was evidence that the father told the mother during the tumultuous marriage, if you leave me, I will try to break you. Secondly, during the time, so 3 days after, the father says, I dreamed of a rope hanging around your neck and you swinging from it. The mother left and went to her family, which I think all litigants do when they separate. Between that time and the taking out of the temporary restraining order, there were multiple conversations and visitation exchanges between the mother and father. They even drafted, and it's in the record, they even drafted agreements on how to resolve their disputes. During that time also, the father was, mea culpa, I am so sorry how I've treated you. You are a great mother. The mother would send photos of the children, and the father would say, I'm so happy they have a community. I'm so happy they're going to a library. I'm so happy they have friends. The father, it's not necessarily that the allegations were at best flimsy and at most false. It's that when he got the TRO, he revealed the motivations. He took the child to the first haircut. He kept telling the mother, we miss you. We love you. Your children need you. It was an effort to try to get her back. That was the sole intent of the TRO. The father, but it foreshadowed what the father's plans were over the course of this divorce. One of the things that's in the record is how the father talked about how heartbroken he was, and then the oldest child started to mimic that behavior of being heartbroken. He enmeshed himself to the child. For the child then at exchanges, then the child starts crying. The child started saying, "Dad says you're a rich." The last word rhymed with something the dad had clearly passed on to her. One of the things about this, it was never absconding. The only issue was the mother told the father where she was, just not the exact address. Because 2 weeks earlier, he told her of her fantasy of her dying. The father was hamstrung by this fact during the marriage that the mother was the primary caretaker of the children. And this was a significant dispute, but there's plenty of evidence regarding the mother was the primary caretaker. The father, there was a Tennessee early intervention because the oldest child, her heart stopped beating through the passage of the birth canal. They had the Tennessee early interventions. The mother missed one visit. The father made less than a third. The mother's testimony was deemed credible regarding she performed most of the caretaking functions, which is why Dr. Hillner's report that I think Judge Upchurch said it somewhat correctly. Judge Upchurch found faults in both, found values in both, but the central issue from Dr. Hillner's report is when it looked how the children behaved around each parent, the children cooperated best with the mother, took directions from the mother, followed what the mother had to say, and I think that's the most important issue in terms of where should the children reside and going to school, where there are a million things between coming home from school and going to school the next day that parents have to rely on the children following them. I also want to say this about the distance, and this is another example of the father's disingenuous behavior. His proposed parenting plan that he eventually filed with the court said, if I'm primary residential parent, I want all of the visitation the mother does here in the Chattanooga area. I asked him on cross-examination, and are you going to do the same if the mother is primary residential parent? Absolutely. I'll get a hotel in the Centerville area. And the record shows because of post-filing divorces, he never did that, not once. But that's exactly what he wanted the mother to do, and so it just another example of his disingenuous and his lack of credibility. The father also minimizes his behavior. There were multiple issues of his rage, and Dr. Hillner's report talks about the lack of validity in his own testimony. Frankly, I think the court had the ability, under the limiting factors of the parenting plan, to find that he had the emotional disturbance because his behavior towards the mother is more than just poor spousal behavior. It can affect your parenting, and the children were present for some of these issues. There was urinating on a marriage certificate. There was yelling. That was played at the trial for the court. And the father repeatedly apologized for this behavior, repeatedly acknowledged it until he filed for divorce. And at the divorce, his testimony when asked was, well, my wife had put me in a very bad place. Took no ownership of it. The father also tried to make mountains out of, at best, molehills, trying to this narrative that he's a more comparatively fit parent. He complained that the mother let the child play with tools. And the proof was that the children used to go in the father's garage and play with him while he was working. That the children wore long sleeves in lieu of sunscreen. And it's not merely that it's petty concerns. It's that that's how he's parenting, which is reflective on the exhibit of the child at the visitation exchanges, where the child is crying, going to mom, and the dad is delighted in that evidence because he thinks it is a validation of his relationship. Again, there were text messages that reflect the father says how heartbroken he was, the child said he was heartbroken, and various other behaviors that concern Judge Upchurch. And so Judge Upchurch, I don't think that the factors require courts to have this tortured logic of, okay, if you weighed factor 1 this way, should you now weigh factor 4 this way? The court found the evidence largely consistent with what Dr. Hillner found, which was the mother was far more aligned to be the school parent, and the father was far more aligned to be the weekend parent. The attack that it is consistent with the work schedules of the parents is inconsistent with the own code that says that courts are supposed to fashion parenting plans consistent with work schedules. The stability of the children is best met with the mother as the school parent, and as I believe the record bears out, Dr. Hillner says every effort is to be made to find a schedule where the father can have 3 nights to find a 4-day-a-week school schedule, which is exactly what the mother did. The final factor at Judge Upchurch is the facilitation. The only attack on the mom's behavior is that 3 days after her life being threatened, she moved to where her family lived. After that, she gave the father ample notice where she was. They met for multiple visitations, and they even tried to resolve the differences in the divorce amicably. At no point did she try to hide the children or keep the children away from the father or file respectfully, a bogus order of or temporary restraining order. She did testify regarding weaknesses of the father, factually regarding his lack of involvement, which was corroborated by Dr. Hillner's observations of both parents with the children and other things, but she wanted a relationship between the children and the father, which is inconsistent to say she did not facilitate a relationship. She was not the one that delved into petty evidence and lied to the court. And so for all of those reasons, the court did not abuse its discretion at all. His findings, he says, were independent of Dr. Hillner's findings, but they both arrived at the exact same place, which is the mother was the far better parent during the school week, and the maximized principles apply, and the father has a majority of the weekends. I have 5 minutes for questions. I appreciate the court.
Thank you so very much.
Thank you, Your Honor.
Yes, sir. Your vote.
Yes, and I probably won't use all 3 minutes, Your Honor, just very briefly. I do want to mention the continuation of the false narrative. My client has been said to be disingenuous because he wanted the mom's visitation to take place in Chattanooga and asked if he would do the same if the children were in Centerville, would he do that? And he did not. The children don't reside primarily in Centerville. This is a 50-50 relationship. There's no reason for him to get a hotel room to spend with these children for 4 days. So that is the disingenuousness of this. I don't know how it came to be that there is a belief that these children reside in Centerville. They do not. They have a 50-50 relationship between Centerville and where my client resides in the Chattanooga area. That's not true. And the judge based his ruling on that fact. And it's just not true. Now, he can say his results were independent of Dr. Hillner's results. Well, he didn't flip the summers like Dr. Hillner suggested should happen, and that the children should reside primarily with my client during the summer months and have weekends with the mother. He didn't do that. So obviously he didn't follow Dr. Hillner's recommendations in those, and that's fine. But it's just an absolute false narrative to suggest that this man did anything to keep these children from that mother. And if she left because she was so afraid of him, you have to ask yourself the question, why did she see him 3 times in less than a month after leaving in fear for her life? 3. It's just a false narrative. She wanted out. She wanted gone. She wanted the kids. She took them. She went 200 miles away and stayed gone. She let him come to Centerville to see them. Great, thanks for that. You moved 200 miles away with my children and you let me come 200 miles to see my kids. So he got a temporary restraining order bringing them back. set down a 50-50 parenting plan to try and be as fair as he could with division of the time between the children. And since that time, somehow this has become the children live in Centerville when they don't. When there's expert testimony that the better school is the Montessori school where my client resides. There is no testimony to suggest that my client is not a better situated parent for these children. There is all of the judge's findings and conclusions are split equally between the parents, but for the fact that dad kept the children from the mother, which is not true. She is the one who left, and the children have resided primarily in Centerville and continuity and stability. And he says it, stability, stability, stability. He says it that way, but it's not true. That's an abuse of discretion. And I have time probably for one or two questions if your honors have any.
I hear none.
Okay, thank you.
Thank you very much. We want to thank the lawyers for your presentation. Your case has now been submitted to this court. You should receive our opinion within a reasonable period of time. Thank you very much, and attorneys may be excused. Madam Clerk, will you adjourn court?
All rise. This court stands adjourned until Tuesday, August the 16th at 9:30 a.m.
Thank you.